Well, welcome everybody. Thank you very much for joining us here. Before we begin, I'd like to acknowledge that those of us in Australia are joining you on Aboriginal land. I join you from Duncan young country and pay my respects to their elders past and present. I also acknowledge the First Nations youth of Australia, in whose hands is held our hope as a nation for a reconciled future. My name's Pauline Wright. I'm the President of the New South Wales Council for Civil Liberties. I'm also the Australian representative on the Union Internationale des Avocats, and I am a former president of the Law Council of Australia. I welcome you all to lawyers across the globe and around the clock for the rule of law for this unprecedented 24-hour rule of law webathon. This panel, presented by the New South Wales Council for Civil Liberties, will discuss racial discrimination and the rule of law, the Black Lives Matter movement, an Australian perspective. We are one of 12 different panels being offered for 24 continuous hours by lawyers' associations worldwide to celebrate, address challenges, and defend the rule of law, all on this YouTube channel. The rule of law is society's legal underpinning, guaranteeing human rights and creating economic opportunity and development. And we lawyers are often the first line of defence. The rule of law is not merely the stock and trade of lawyers, it's our core value, and it's the way society stays together and functions. The universal commitment of the world's lawyers to the rule of law inspired us and many other lawyers' associations to join forces and launch this first of its kind webathon. And we're really proud to be part of it at the New South Wales Council for Civil Liberties. We have a stellar panel with us in Australia today, each eminently qualified from their unique experiences to shed light on this really important and vexed issue within Australia. Our keynote speaker is Dr. Teela Reid. We'll then hear in turn from Cheryl Axleby, John Mckenzie AM, Dr. Thalia Anthony and Barry B.J. Duncan, and our panel will then engage in a facilitated discussion followed by Q&A. So I'll start by introducing you to our keynote speaker, Dr. Teela Reid. Teela Reid is a proud Wiradjuri and Wailwan woman and lawyer, currently working with Legal Aid New South Wales. She has extensive experience practicing criminal, civil and administrative law. She was born and raised in Gilgandra in Western New South Wales and comes from a family of advocates in the New South Wales land rights movement. Teela was involved as a working group leader on Section 5126 in the constitutional dialogue process that culminated in the Uluru Statement from the Heart. Previously, Teela was Australia's female Indigenous youth delegate to the United Nations Permanent Forum in New York that inspired her journey to become a lawyer. She completed her postgraduate Juris Doctor from the University of New South Wales in Sydney and was named on the university's Law Dean's Women of Excellence list. Upon graduation, Teela was appointed tipstaff to Her Honour Justice Lucy McCallum in the New South Wales Supreme Court. Teela was the first Aboriginal person to be elected on the University of New South Wales Law Society as Vice President, Social Justice, where she was the founding director of the university's Law First Peoples Moot. She was the inaugural recipient of the New South Wales Indigenous Barristers Trust Award. And in 2017, Teela was selected to attend Harvard University as a global emerging leader. On her return to Australia, she fearlessly took Prime Minister Turnbull to task on Q&A, a TV show here in Australia, after his dismissal of the Uluru Statement from the Heart. Teela Reid, it's a great honour to have you address us today. So I'll hand the floor to you.
Yama. Hello, everyone. Nurembang Merang Yingyalgi, Yama Yundi Teela. Nadu Winangnangei Yinjamara Marangay May. Jirinya Gadigabu Nurembangabu. I just said in my language, Wiradjuri language, I honour and pay my respects to the Gadigal people born first to this country, and I honour this country as the first peoples that belong to this country. It is a pleasure to be the keynote speaker. Of course, that we have a distinguished panel coming up, and I'm sure they'll have a lot more to say about this particular topic. But I would like to start by saying this, that here in Australia, we are living and walking on the unceded lands and territories of the First Nations peoples. As said, you know, this is going to be couched in the topic of the rule of law, and with respect to not only my role as a lawyer, but also a First Nations woman, one of the things that we must set the context for before we talk about, in particular, where we're at in Australia, is that we have a very ancient law operating here, the law of the First Peoples, and that the colonial law is not the only law. So I acknowledge that sovereignty on these lands and waters has never been ceded. With respect to my presentation, I will distill my keynote speech in 3 distinct topics and try and set the context for the panel with respect to talking in particular about, firstly, I will speak to the factual context with respect to what we have had, which is the Royal Commission into Aboriginal Deaths in Custody. This year marks 30 years since that Royal Commission. That's the first issue I'll speak to. The second issue I will speak to is with respect to the global Black Lives Matter movement and the impact that has had here in Australia, and talk about not only the similarities but the differences with respect to Black Lives Matter, and how it's not just a hashtag, but it's an important global movement. And the third issue I will speak to directly, which is just raising the question then with respect to where we are at in Australia, setting the context of Indigenous incarceration and what is a complex area of Indigenous policy here in Australia at both the jurisdictional level and the federal level. So in relation to the first topic, which is the Royal Commission into Aboriginal Deaths in Custody, 2021, this year marks 30 years since that important moment in our history. The Royal Commission into Aboriginal Deaths in Custody in Australia was established in 1987, albeit when I was just 2 years old, and we are still fighting this struggle. That was in response to a public outcry at that moment in time for a Royal Commission to examine what was at that point 88 cases of men and 11 of those of Aboriginal women who had died in custody between 1980 and May 1989. As a result of Australia's Royal Commission into Aboriginal Deaths in Custody, there were 339 recommendations. In this country, we have had recommendation after recommendation into examining Indigenous incarceration. So arguably, I'm going to put, it's that Australia has been ahead of the rest of the world with respect to interrogating deaths, with respect to investigating Black deaths at the hands of the state. It is my argument that our civil procedures have been functioning fine. It's 30 years we've had the most enormous commission on this continent. We are a rich, we are a wealthy nation. We have had inquiry after inquiry here in Australia. It hasn't just been the Royal Commission into Aboriginal Deaths in Custody that has been significant in terms of talking about the rapid and rising rates of Indigenous incarceration. Another example of a commission has been Donnellan. That is a process, Royal Commission only a few years ago, that led to further recommendations to reform our prison industry in the Northern Territory. Yet what we are seeing after Royal Commission after Royal Commission, for example, after Donnellan, has been now the Northern Territory government is on the verge of passing legislation that would further erode bail laws, that would further diminish the presumption of innocence, and undoubtedly disproportionately affect Indigenous people, in particular Aboriginal youth. Now, what we are seeing is a rollout of recommendations not only here in Australia or Northern Territory, but also in New South Wales. Australia is a country that likes to talk about Indigenous incarceration, but take absolutely no action. To address Aboriginal deaths in custody in Australia, we need to look beyond the last 3 decades since the Royal Commission into this national disgrace and examine how colonisation has perpetrated genocide against First Nations peoples on this soil. The ongoing indifference towards Aboriginal lives in Australia has resulted in an estimated further 470 Aboriginal deaths post the Royal Commission, and not one conviction for those responsible since the Royal Commission handed down those findings 30 years ago. That's an entire generation like mine who have now inherited this same struggle that our past generation had fought for when the Royal Commission was conducted. On this continent, the systemic erasure of First Nations lives, languages, and law from our own lands has been the product of a society and a penal colony as Australia founded on genocide. Killing Aboriginal people on this country has always been a byproduct of the colonial project. It started with massacres here in Australia. It persisted with missionaries, and the remnants of this violent past are manifested in the mass incarceration of Indigenous peoples on this continent. It is a fact that we are the most incarcerated people on the planet. If we are honest about Australia's treatment of Aboriginal people, we should absolutely call it for what it is: genocide. The United Nations definition of genocide includes acts committed with intent to destroy, in part or in whole, a national, ethical, racial, or religious group. Such acts include deaths of causing harm, including mental harm, and imposing limits on birthing and forcibly transferring children to another group. Australia is a perpetrator of this offence. This is an issue that we have not come to terms with as a nation. In terms of dealing with Aboriginal deaths in custody on this continent, and if Black lives do matter in Australia, we as a nation need to confront some hard truths. Colonisation on this continent is not a process that suddenly stopped as a result of the Royal Commission or as a result of our Prime Ministers saying sorry and not acting, or promises even including to close the gap. Australia is a nation fixated on incarcerating Indigenous peoples. It started as a prison colony and it continues to be an incarceration nation. For example, since the Royal Commission into Aboriginal deaths in custody 30 years ago, the incarceration of First Nations women has increased by 148%. In the Northern Territory, 100% of those incarcerated in youth detention have been Aboriginal children. This is what systemic racism looks like in the Great Land down under. We go on building more prisons. The jurisdiction I practice in, New South Wales, alone has spent $3.8 billion spent on building more prisons. Proposals that are culturally safe, that are led by communities such as the Wallama Court option designed to divert Aboriginal people away from the criminal justice process, have been continually dismissed by our parliaments. This is not a matter of our communities not taking action. It's a matter of politicians continually dismissing our voices. Aboriginal communities are suffocating in bureaucratic red tape. governments continue tough on crime rhetoric. The willful failure to act on Royal Commission's recommendations amounts to a modern-day genocide on this continent. Recommendation 339 of the Royal Commission called for, I quote, all political leaders and their parties to recognise that reconciliation between Aboriginal and non-Aboriginal communities in Australia must be achieved if the community division, discord, and injustice to Aboriginal people are to be avoided. A key feature it found was to implement the right to self-determination for Indigenous Australians. In the jurisdiction I practice in, that New South Wales, we have a robust coronial process. From the perspective of New South Wales, our coroners' courts, our investigative courts are functioning fine. They are robust. We have a coroner, a state coroner in our jurisdiction that had recently made this public statement across Australia on national media. Coroner O'Sutherland said this about deaths in custody here in New South Wales. I quote, every First Nations death in custody represents the loss of a valued family member and community member. Every First Nations death that comes before this court is a tragedy. We cannot separate the issue of First Nations deaths in custody from the overrepresentation of First Nations people within the criminal justice process, nor can we separate it from our colonial history. Coroner O'Sutherland went on to say, a key theme in the Royal Commission into Aboriginal deaths in custody 30 years ago, and one that also reflected in its 339 recommendations, was the importance of self-determination. And to quote directly from the report, the whole thrust of this report is directed towards the empowerment of Aboriginal society based on the basis of their deep desire held to demonstrate their capacity and their democratic right to exercise, according to circumstances, maximum control over their lives and control over their communities. That was written 30 years ago, and the words of the report still hold much force. So with respect to the historical context in Australia, we're a nation that has never dealt with a fundamental wrong. The fundamental wrong, as a matter of a rule of law, is the rightful place of our First Nations, the unlawful invasion of our unceded lands and territories. I will return to this point later, but I want to draw attention to now the Black Lives Matter movement and what that means for the Australian context. According to the Black Lives Matter official website in the United States, it was created, they said online, quote, Black Lives Matter was founded in 2013 in response to the acquittal of Trayvon Martin's murderer. Black Lives Matter Global Network Foundation is a global organization in the US, UK, and Canada, whose mission is to eradicate white supremacy and build local power to intervene in violence inflicted on Black communities by the state and vigilantes, by combating and counteracting acts of violence, creating space for Black imagination and innovation, and centering Black joy. We are winning immediate improvements in our lives, end quote. So what did the Black Lives Matter mean for here in Australia? In Australia, in the beginning of 2020, the Black Lives Matter movement was amplified on this continent by the death of George Floyd. It shone a light on Aboriginal deaths here in custody, but it revealed a very deep-seated issue in our society. 30 years since the Royal Commission into Aboriginal deaths in custody, most Australians were still shocked to find that Indigenous peoples continue to die at the hands of the Australian state. And for people of colour, disproportionately affected by the penal system. With respect to Black Lives Matter, there were similar demands in Australia. For example, similar demands such as charging those with respect to who had been responsible for the deaths of Aboriginal people in custody. We have had a number of, I won't identify each of them, the panel might identify each of them, but since the Black Lives Matter groundswell grew here, there have been charges laid. So that was a positive impact of the Black Lives Matter movement. We've had calls for inquiries, and for those inquiries to be independent of the police force. There have also been, and if I'm making a critical analysis about the movement here in Australia, it's my view that the demands have somewhat been also inconsistent with the Black Lives Matter movement. For example, in some jurisdictions across the country, there were first calls to abolish prisons, to abolish police, and abolish the judicial process, but then charge officers who are alleged to have been responsible. I think what we need to critically analyse here in Australia is the way in which ultimately the issue is that there is a real power imbalance in relation to First Nations peoples and what the calls to action are for. We are a large, diverse population. During the peak of COVID-19 and the Black Lives Matter movement, we had some of the largest protests across the continent. Aboriginal people here in Australia account for only 3% of the total population. This reveals a deep-seated racism in trying to enforce and implement the recommendations that not only come out of the Royal Commission into Aboriginal Deaths in Custody, but other inquiries that have made recommendations. This is a country that there is no lack of answers in this nation. There are many public responses written in black and white on parliamentary reports on how to address Aboriginal deaths in custody and to abolish prisons and defund the police. What we have, though, is a lack of political will when it comes to change with respect to systemic change and stamping out in our nation systemic racism. So where are we at with respect to addressing these particular issues in specifically deaths in custody? As an activist, I've traversed the continent on many issues, in addition to none other than the Uluru Statement from the Heart. As an activist, I have spoken to many different communities. I am an advocate for prison abolition. I am an advocate for defunding the police. And I am an advocate for addressing the fundamental wrongs that this nation still has not yet addressed. We have seen recently a groundswell of, and I'm going to end with this actually, the context of where we're at now in terms of trying to achieve systemic change in Australia. We are an interesting nation at a crossroads of many changes. We are 250 years into invasion and colonization. We are 250 years into still not addressing the unfinished business between First Nations peoples and the rest of the Australian population. This is distinctly different. This is distinctly different to the Black Lives Matter movement that has recently gained groundswell across the globe. We are a country that operates as its status quo, racism. I was a working group leader on Section 5126. It's a draconian law written within our constitution that allows our federal parliament to make not only laws to the benefit of First Nations peoples, but our parliament is empowered to make laws with respect to the detriment of First Nations peoples. And that is one of the fundamental issues at the heart of my advocacy. It's my argument that we need power when we are alive, not when we are dead. And so where we are at now is we are on a journey, and I'll leave this forum with respect to my final reading for the rest of the webinar in relation to the Uluru Statement from the Heart that I hope resonates with the global community. This is a legal document that has been issued from First Nations peoples to the Australian public, and we are on a journey as a nation to achieving these reforms. We gathered at the 2017 National Constitutional Convention, coming from all points of the southern sky, make this statement from the heart. Our Aboriginal and Torres Strait Islander tribes were the first sovereign nations of the Australian continent and its adjacent islands, and had possessed it under our own laws and customs. This our ancestors did, according to the reckoning of our culture from the creation, according to the common law from time immemorial, and according to science more than 60,000 years ago. This sovereignty is a spiritual notion, the ancestral tie between the land or Mother Nature and the Aboriginal and Torres Strait Islander peoples who return therefrom must remain attached thereto and must one day return thither to be united with our ancestors. This link is the basis of the ownership of the soil, or better, of sovereignty. It has never been ceded or extinguished and coexists with the sovereignty of the Crown. How could it be otherwise that peoples possessed a land for 60 millennia and this sacred link disappears from world history in merely the last 200 years? With substantive constitutional change and structural reform, we believe this ancient sovereignty can shine through a fuller expression of Australia's nationhood. Proportionately, we are the most incarcerated peoples on the planet. We are not an innately criminal people. Our children are alienated from their families at unprecedented rates. This cannot be because we have no love for them. And our youth languish in detention in obscene numbers. They should be our hope for the future. These dimensions of our crisis tell plainly the structural nature of our problem. This is the torment of our powerlessness. We seek constitutional reforms to empower our people and take a rightful place in our own country. When we have power over our destiny, our children will flourish. They will walk into worlds and their culture will be a gift to their country. We call for the establishment of a First Nations voice enshrined in the Constitution. Makarrata is the culmination of our agenda, the coming together after a struggle. It captures our aspirations for a fair and truthful relationship with the people of Australia and a better future based on justice and self-determination. We seek a Makarrata Commission to supervise a process of agreement making between governments and First Nations and truth-telling about our history. In 1967, we were counted. In 2017, we seek to be heard. We leave base camp and start our vast trek across this country. We invite you to walk with us in a movement of the Australian people for a better future. Thank you.
Thank you very much, Teela Reid. That was a really penetrating and interesting insight. I think that some of the things that you mentioned, defunding police, stopping investment in prisons, coming to that recognition that talk is not enough. We've got the solutions already, really sets the tone for today's discussion. And I'm sure that the rest of our panelists will expand on some of those points that you made so well, Teela. I understand that you do have to leave shortly, so we'll forgive you for that. We know you've got work to do. So thank you very much for giving us your time today. It was a really fascinating opening, and it's certainly going to stimulate some discussion. So thank you very much.
Thank you. Yalu, everyone.
Yalu. Our first panel speaker is Cheryl Axleby. She's the co-chair of Change the Record, Australia's only national First Nations-led justice coalition that aims to end the mass incarceration of First Nations peoples and the disproportionate burden of family violence experienced by Aboriginal and Torres Strait Islander women and children. Cheryl is a proud Narungga woman who's passionate about improving the quality of life of her people. She's spent the last 40 years working within the Aboriginal community, federal government and South Australian government to improve the lives of First Nations peoples. She has experience working within the Aboriginal community sector, law and justice, women's issues, family violence, youth justice, child and family services, and is currently working in the Aboriginal community housing sector. Cheryl has held the positions of CEO of Aboriginal Legal Rights Movement and National Co-Chair of National Aboriginal Torres Strait Islander Legal Services, the peak body representing Aboriginal legal services in Australia, and is currently, as I've said, working in the community housing sector. She is a cultural change advocate and an effective champion of justice reinvestment and reconciliation, which Teela has touched on. She's alarmed by the ever-increasing number of Aboriginal people trapped within the criminal justice and child protection systems and works every day to change these dangerous systems that oppress and harm her people. So thank you very much for taking part in this webinar today. Cheryl Axleby, over to you.
Thank you. Thank you very much. And I just want to take a moment to reflect on Teela's wonderful keynote address. It instills a lot of powerful emotions for me as a First Nations woman. And again, for many of our people who are living in this country where we're still struggling to see justice being achieved for our people, particularly for accountability with Aboriginal deaths in custody, but also with the overrepresentation of our people in the justice system in this country, which, you know, when I'm thinking about 30 years ago in regards to the Royal Commission, you know, I was probably around about 27 years of age, working in an Aboriginal legal service way back in that period of time. And I remember that journey and that significant report and the hope, I suppose, that a lot of us had in our communities that these recommendations would make a great difference in the lives of our people going forward. And I just have to say it's very disappointing, you know, to see to date that we're still dealing with the over-incarceration rates of our people. And as Teela mentioned, there's been over 470 deaths since that Royal Commission. And in the last month alone, 5 weeks probably, we've had 7 Aboriginal deaths in custody occur in this country, and still without justification. But I feel like to firstly just acknowledge that I'm meeting on Kaurna country, Adelaide in South Australia. Pay my respects to the Kaurna elders, past, present, and emerging. And also, as Teela has mentioned, I'd like to acknowledge that, you know, Kaurna country, as all our Aboriginal nations around Australia, you know, is stolen country. Sovereignty has never been ceded, and we still, to this day, seek for truth and justice to be told in this country about the colonisation of this country. So my focus is, I suppose, having a bit of an overview in regards to talking about the Black Lives Matter and its impact in Australia, but also, you know, just to take us back that the people that we're talking about, you know, people who have lost their lives within the justice system. Far too often we talk about numbers and statistics, and we just need to get back to actually putting names to faces where we can, where it's culturally appropriate, so that we remember that these are real peoples and that, you know, families today are still grieving for their losses. And every death in custody that does occur reignites the grief and pain and the grief and loss that our families experience in this country. So every death is felt by every Aboriginal Torres Strait Islander person in this country. The struggle to ensure that Black Lives Matter, the way that white lives matter, is a struggle that people of colour are fighting all over the world. Aboriginal people in Australia are the most incarcerated people on earth, and we know the pain that Black America felt in the wake of George Floyd's death, because it's the pain that we feel too. When George Floyd's brutal death kickstart waves of protests here and around the world, we added our voices and called for change. But the reality is First Nations people have been fighting for justice in Australia for a long time. Over 470 Aboriginal people have died in custody since the Royal Commission. And the conviction of Derek Chauvin in the USA, who's been found guilty of the murder of Greg Floyd, is a small step towards accountability. But the conviction of one police officer will not fix a deeply racist, broken policing system. And, you know, there's lots of different views about whether the system's broken or whether it's, you know, set up and intended to do, you know, what it's always been set up to do. You know, I'm not going to debate that issue, but I do want to say that, yes, you know, the system is set up, you know, in Australia to do what it was intended to do. But there are many mechanisms of the system that I see is broken. And through my experiences working in youth justice and child protection areas in particular, you know, just seeing how the system keeps our people in the system and drawing our people back into the system means that we need to be doing something different. So here in Australia, we're still waiting for that accountability. There's not been one single conviction of the 470 of our deaths of our people who've died in police or prison cells. The 1991 Royal Commission into Aboriginal deaths in custody was meant to put an end to our people dying in cells. Instead, its recommendations have been repeated in numerous reports, as Teela has already said, inquiries and coronial inquests, and yet the majority of them have not been implemented. And I also want to point out that a lot of our families struggle to get legal representation. One, to have an independent review, you know, at the time of their loved one has died in custody, and also to have representation before the coronial inquests. So a lot of the Aboriginal legal services in particular really struggle in Australia to be able to provide that funding and support for families. And this again just demonstrates that where alleged perpetrators of the system who have caused the deaths of our people are very well funded, represented before the system, and where our people still struggle to receive that justice. We've lost too many lives to tell all their stories. In September 2019, Miss Clark was shot by police in Geraldton, Western Australia. She died in hospital. On the 9th of November, teenager Kumanjai Walker was shot by police and killed in UNSW in Northern Territory. And in both cases, police officers were charged with murder, and that probably is the first time that we've actually ever seen police officers actually charged. But the question remains whether justice will be delivered, because they're still yet to go through the system, and we're still yet to see whether justice will be achieved for families and for those people that have died. In the last 2 months, as I've said, 7 First Nation peoples have died behind bars, and you know, and we will continue to see that, particularly with the introduction of harsh bail laws now being further introduced in Queensland and particularly in the Northern Territory, you know, and which is astounding considering that the Donnellan, the Royal Commission in the Northern Territory into the youth justice system over there, and in regards to the Donnellan Youth Detention Centre, highlighted some of the most disgraceful mistreatment of Aboriginal young people in custody that we have seen in this country. And let me reassure everybody, it's not just Northern Territory where our youth are being subjected to such treatment. There'll be no accountability and no justice in Australia until police stop investigating police, and we have independent and transparent oversight of our police and prison systems. Our people are put into prisons at the highest rates in the world, and we incarcerate because of poverty, discriminatory policies and over-policing. Our children are taken away from their parents and are locked up in youth detention centres at far higher rates than non-Indigenous children, and also at far higher rates now than at the time of the stolen children's generation. We do not need to look to America to see the consequences of systemic discrimination, because we can see it right here. So 30 years ago, the Royal Commission was tasked with investigating the deaths of First Nations peoples in custody. It produced hundreds of recommendations, 339 to be exact, to save lives, from big structural reforms right through to fixing prison cells to make them less dangerous. It recommended handing power back to First Nations peoples, investing in self-determination and supporting community control. It recommended changing police practices, independent oversight and accountability, and repealing discriminatory laws. And yet here we are, 30 years later, still waiting for these things to happen. In those 30 years, state, territory and Commonwealth governments have failed to implement the majority of those recommendations. And as a result, First Nations peoples are still dying at horrendous rates. In many cases, governments over the last 30 years have actually made things worse. Despite many commissions, reports and inquiries since the Royal Commission, state and governments have for the most part continued with their tough on crime, law and order, political agendas. And, you know, for many, many years, as long as I can remember, Aboriginal issues are always what I call the political football when it comes to the political, you know, election period time. And, you know, far too often we are viewed in a negative context by the politicians and the parties. State and territory governments continue to lock up our children as young as 10 years of age. Despite medical consensus that locking up children can cause lifelong harm, we have seen as recently this month, as I've already said, in Northern Territory and Queensland governments introduced new punitive laws that actually target young people and will drive up the numbers of our kids behind bars. We have been campaigning against these laws and to get state and territory governments to raise the age of criminal responsibility to at least 14 years of age, which is in line with international human rights and the Conventions of the Rights of Children. And also we've been, you know, seeing internationally in other countries that they've actually been taking this step and looking at a therapeutic response to children that come into the justice system rather than a criminalised one, with great success. State and territory governments continue to pour money into building and expanding more prisons. For example, in Victoria, they're building the new Cherry Creek Youth Detention Centre and expanding the Dame Phyllis Frost Women's Prison. Every time there is a tragedy, we see governments respond to media pressure by introducing knee-jerk law changes and make it harder to get bail and see more of our people locked up. Police harassment and brutality remains an extremely common occurrence for our people and for Aboriginal and Torres Strait Islander legal services, and who are nowhere near adequately funded to meet the demand put on our services. And just an example of that, you know, our people, I'll just go through to the Australian Law Reform Commission report that was handed down in 2018. A report that still has not had the government provide any response, which is very disappointing in regards to those recommendations. And then the actual report again highlighted and just reaffirmed a lot of the issues that were identified in the Royal Commission to Aboriginal Deaths in Custody, Royal Commission reports and recommendations. And just to give you an example, that at the time in 2016, the national prison population for Aboriginal and Torres Strait Islander people was around about 20 in every 1,000 Aboriginal and Torres Strait Islander people were incarcerated in this country. And since then, it's actually increased. And it increased, Aboriginal incarceration rates increased by 41% between the period 2006 and 2016. And in particular, at that time, 34% of Aboriginal and Torres Strait Islander women made up the prison population, being the most highly incarcerated cohort in the justice system in comparison to non-Aboriginal women, which was significantly lower. So those numbers are important. And I know that sometimes we get caught up on statistics, but when we put it in this light, it demonstrates the inequity of our people with, you know, before the justice system. So we are a long way from seeing the implementation of the Royal Commission and an end to the mass imprisonment of our people. But these systemic reforms are we need if Black Lives Matter are to truly matter in this country. The solutions are very, very clear to us. As Teela had already mentioned, that there have been lots of solutions lots of reports, lots of recommendations have been put forward to government, and there is a lack of political will. So governments must repeal the discriminatory laws that see our people locked away for minor offences. Our Aboriginal and Torres Strait Islander children, women and men hold the highest remand rates in the justice system. And when we talk about the 10 to 14-year-olds age group, around 60% of those children locked up in custody in the 10 to 14 years of age, and actually held on remand, and are actually doing longer time on remand than they would if they actually received a sentence. So there is a real civil liberty injustice that I feel in the way the justice system is working. And the other thing that we need to do is, of course, I talked about raising the age of criminal responsibility, not only to protect our children, but to break the cycle of the intergenerational incarceration of our people, and to give our future generations the future opportunity to not live a life within the system. And they must introduce independent oversight and accountability of police and prisons. And that is probably something that I have been really trying to advocate for many, many years, because police still investigate police. And, we've had deaths in prison where prisons are still investigating their own prison officers, and that must stop. So it's up to all of us in the legal community, more broadly, to build the public pressure and momentum to force politicians to take action. And I just want to also, when we talk about police being charged, well, only just this week, you may have seen in the media of the young Aboriginal youth that was mistreated some 18 months ago. It came to media attention where a police officer kicked the legs out from under this young fella, and it was caught on camera. It was actually quite, again, horrifying about the way that our youth are being treated in this country by police. And we heard that this week that the police officer is finally going to be charged with an offence 18 months after the incident happened. So that's how slow the justice is, in regards to Aboriginal Torres Strait Islander people. And in closing, I just want to say that we need to take a moment, get back to a couple of things in regards to the Uluru Statement of the Heart, for which I was also privileged enough to be involved in, is that we need to reflect and take a moment to reflect that the majority of Australians in this country are living off Aboriginal disadvantage. And, that is where First Nations people, we are the poorest in our own country, yet many others live off the wealth of our land. And I think it's really important that I like to finish on that note, because I think it's important that we need to take the time to reflect that the level of disadvantage in this country and the level of advantages given to non-Aboriginal people in this country, these are some of the areas that we still need to address. And I'd love to see that be addressed in this country through truth-telling going into the future, and also for having our voice enshrined going forward. So I just want to say thank you for the opportunity.
Thank you very much, Cheryl. I was on mute, of course. Thank you very much for that very perceptive opening from you. Some of the issues that you raised, like the bail laws, the percentage of young people on remand, the minimum age of criminal responsibility and punitive laws. Justice reinvestment is one answer, I think, Cheryl. But those suggestions that you've made around repealing those discriminatory laws, raising the minimum age of criminal responsibility and independent oversight are really important. Now, the next speaker that we have is John Mckenzie, and I'm sure he can shed some further light on these issues. John is, of course, the New South Wales Legal Services Commissioner, but importantly, he was the principal solicitor at the 1987 to 1991 Royal Commission into Aboriginal Deaths in Custody, and he received his AM for his significant service to the law, the legal profession, and to social justice for the Indigenous community. And for over 40 years, John held senior positions in Legal Aid New South Wales. He was Chief Legal Officer for the Aboriginal Legal Service from 2006 to 2014 and has been the Legal Services Commissioner in New South Wales since 2015. John, it's a real pleasure to have you with us today, and we look forward to hearing from you.
Thank you very much, Pauline. And let me firstly want to acknowledge the traditional owners, the Gadigal people of the Eora Nation, and I pay my respects to them, to their heritage and to their culture. I suppose my role, well, my position on this panel, if you like, is a person who still survives from that team of idealistic people who worked so hard 30 years ago to put together firstly the investigations into the approximately 100 deaths across Australia, then to draw out of it the lessons that needed to be learnt and the recommendations. I and others, I should say, have been working in the 30 years since to try to get governments of any persuasion in any part of this nation to actually meaningfully implement those recommendations. And as you can imagine, it has been a matter of great disillusionment, disenchantment, and rising anger, I suppose I should say. But that is nothing compared to the Aboriginal people, and especially those Aboriginal and Torres Strait Islander families who have lost loved ones to deaths in custody. But even wider than that, to all of the Aboriginal families and communities who see far too many of their members incarcerated within the Western justice system, sometimes coming out quite badly affected by things that might happen in there. What I'd like to really, first point that I'd like to make today, and I'll try and keep brief because I just want to set a little bit of context. I think it's important from my point of view, and something that I've really perhaps focused on more and more in recent years, is as hard as we try, and many of us have tried, and we need to continue on trying to reform the system of the criminal justice in Australia and its states and territories, that is never going to be enough. What I have realised over the years is that unless the more fundamental, widespread changes are made within the Australian society, and this has got to frankly and fearlessly face up to the racism that tragically seems to be all too ingrained in our national psyche. Until those underlying issues are really dealt with, it seems to me that we're playing a game of three-dimensional chess with the law enforcement, the criminal justice system, and the bureaucrats who put government policy into action. That no matter what changes are made, in a way, to the criminal justice system, and many should be made, by neglecting, I think, quite purposefully and deliberately, the fundamental calls, which I think can be summed up by the recommendation saying self-determination is the fundamental thing that needs to be provided and handed over from we as the invaders of this sovereign land. That needs to happen in order to allow everything else to start to right itself. And I'm a huge supporter. I applaud at every opportunity the wonderful Uluru Statement from the Heart and its measured but heartfelt cries and proposals for a way working forward. And I do see that as absolutely fundamental to any real progress being made. But But just coming back to the actual issue of the deaths in custody in regards to Black Lives Matter, as was highly came to prominence last year. I'm a great believer in, and I think to give some of the commissioners with whom I had the pleasure of working at the Royal Commission in particular, I want to pay my great regard to Commissioner Hal Wooten, who I had the opportunity to work under for a great part of the Royal Commission. And I am one of perhaps the few people lawyers that is, that worked from the very beginning in 1987 to the end and the final report compilation in the early months of 1991. So one of the great things that many of the commissioners, and particularly Commissioner Wooten, did was that they did very in-depth, detailed and, shall we say, whole of person reports into each individual death, into the life of each person that died and into which we investigated. And it is from those individual reports that I think perhaps may be worth many people, especially if we ever do get anyone in government to take it seriously, to actually go back and read some of those individual reports, because I, of course, being a bit of a nerd about such things, have every case report from the Royal Commission and all its underlying issues, papers and all the rest at home, and from time to time I go through it. But just reading some of the narrative of the lives of some of these people who died, and the treatment that the Royal Commission gave to them and their families, and the lessons that they proposed to be learnt from it, I think perhaps maybe a way of getting people to drop this complete indifference to this topic, because that's what I believe, unfortunately, the majority of Australian people do have to this topic. And that is to personalise it and to get down into the lives of some of them, read those individual reports. So I do make that as a commendable thing that perhaps some people might be able to do. The other thing I'd like to say is that government is never going to be the whole answer to this whole issue. That's become apparent to me over the 30 years. What I've seen is governments, via their senior bureaucrats, duck and weave, pretend that they're implementing recommendations when they're doing nothing of the sort, use all sorts of bureaucraties, legalese, all sorts of jargon and weasel words, if you want to get down to it, but never really addressing the major systemic changes that are needed in society, let alone within the criminal justice system. I'm a great supporter of the recently emerging justice reinvestment movement and scheme. I'm a particular supporter of the pilot program that has been running in Burke in northwestern New South Wales for several years now. I think it really does start to show the way that what is needed is community-based, community-controlled initiatives for them to be able to work in a way adjusting their own societal happenings within, in this case, a previously very troubled country town, to be able to demonstrate that. But that was all done because it was not government funded. We didn't have government bureaucrats telling us what to do. And I've come to a conclusion that the less that we have actual governments in charge of any operational levers in regards to these sorts of things, the better, because on my experience, every person, good intentioned as I don't doubt that they are, but after a very short period of time for working for a government department, my observation is that their primary allegiance is to the department, the name of the department, the good reputation of the department and the minister, and not to the people that the service is supposed to be providing. So I'm a great believer in community control. It does seem to be one way of doing it is to tap into the philanthropic funding source, but it shouldn't only be the only one. Surely governments can see their way clear of their egotistic failures to be able to hand money over and not insist on day-to-day bureaucratic changes. So I make that as a general observation as well. Perhaps lastly, I'd just like to make this statement that really, as someone who has tried to do something about this, as indeed many people, especially First Nations people all over Australia, who've been trying to do something about this ever since our report was published in 1991. We need to keep trying, but I am greatly heartened by the wonderful younger First Nations advocates who are already demonstrating a wonderful ability to be able to argue persuasively, intelligently, and with great authority. And I think there's no greater example of that than what we had the privilege to witness in Dr. Teela Reid's opening piece to this session. They are the people who give me heart. They are the people who, if I can be of any assistance to them, I'd love to. But I'm also very clearly of the view that a new generation, a new breed of advocates, which is up and coming, they need to do the running. And I think we, people who tried our best 30 years ago and continue to try over the intervening years, need to realise that the best job that we can do is to support those people and not get in their way. So all power to them, and thank you for the opportunity for joining you today.
Thanks very much for that opening, John. As for Cheryl's, I'm looking forward to expanding on some of those observations in our discussion, but you're absolutely right about the youth and the young people who are taking leadership roles like Dr. Reid. We're well served by those people, and it really is in their hands that our nation's hope is held. I think it's absolutely true. Like you, I'm really heartened by them and hold a lot of hope. The next speaker is Dr. Thalia Anthony. Dr. Anthony is a professor of law at the University of Technology in Sydney. She's a teacher, mother, activist, and proud Cypriot who lives and works on the stolen land of the Gadigal people. Her research focuses on the colonial legacy and systemic racism in legal institutions. Her book, Indigenous People, Crime and Punishment, highlighted the complicity of the courts in the carceralism of First Nations people. She works with local Aboriginal organisations such as Deadly Connections, Mckenzie and Aboriginal Legal Services to strengthen sites of resistance and further self-determination. So thank you very much for taking time from your busy schedule, Thalia. Over to you.
Thanks, Pauline, and it's an honour to be here. I'd like to honour the traditional owners of the land I'm on, the Gadigal people of the Eora Nation, and I want to especially commemorate First Nations people who've died in custody on this land, including TJ Hickey, Patrick Fisher, Paul Kearney, and David Gundy, who was shot by paramilitary forces and died at Royal Prince Alfred Hospital. I send my solidarity to their families who are still struggling for accountability and justice. I also recognise the elders and activists who've taught me over the decades in Sydney, including Auntie Jenny Munro, Bronwyn Penrith, Linda Junko, and Lizzie Jarrett, and thank them for being not only my role models, but also role models now for my own children. And I'm grateful for everyone on this panel for being such inspiring campaigners. It's nice to be around kindred spirits, and I feel like on that basis I'm going to be a bit repetitive, but it's amazing how many times we can send this message and still, you know, we need to call it out louder and louder because there's a lot more listening that needs to be done. So I'm going to talk a little bit about what Black Lives Matter here means and about the struggles. And just to be very clear, that Black Lives Matter in Australia preceded the official movement that emanated in the United States. I know that growing up in the 1980s, I was part of protests against over-policing and Aboriginal deaths in custody, including protests on Invasion Day in 1988, where there were tens, if not hundreds of thousands of people calling out deaths in custody. And the police presence was terrifying. And it led to the formation, this period of the Committee to Defend Black Rights that was led by Helen Boyle and others in the late 1980s. So in Australia, there's a long legacy of over-policing and over-incarceration. And this really did intensify in the 1960s and 70s, but I'll just briefly outline for an international audience some of this context. So prior to the 1960s, the colonial containment of First Nations people occurred through segregation on missions, government settlements, and places of employment, such as cattle stations and homesteads. Aboriginal people's lives, including their money, movement, children, and marriages, were controlled by Aboriginal protectors. And these so-called protectors were white people who worked in conjunction with police to subordinate, assimilate, and extinguish Aboriginal peoples and their culture. So right from the late 1700s, we saw police and native trackers exercise brutal tactics to colonize, and we're still experiencing this legacy today. In the 1960s and 70s, there was a shift because the Aboriginal Acts that controlled Aboriginal people were replaced. And as Aboriginal people were moved out of missions and settlements, the street police became central arbiters over their lives, and police would use their powers to move on Aboriginal people, question, search, detain, and coerce. And this is still seen today. Police racism and the over-policing of Aboriginal people was well documented in Redfern on the eastern coast and Perth on the western coast in the 1970s, and led to the formation of Aboriginal legal services across the country. There was also major concerns around over-policing in small country towns and negligible accountability. And around that time, we started talking more and more about arrests being made for very minor offences, such as the trifecta of offensive language, resist arrest, and assault police. And then into the 1980s, the police brutalisation and deaths in custody became a major focal point of their campaigns. So there are very deep roots to this struggle, and many losses, including John Pat, David Gundy, Lloyd Boney, many families who've had to suffer on this journey. So today, and just to say, that led into the Royal Commission in 1987 with its report released in 1991. It was hoped that it would be a watermark and a turning point. But unfortunately today, First Nations people are 10 times more likely to die in custody compared to a non-Indigenous person. So we've gone backwards in many respects. A large portion of the recommendations were directed to reducing Aboriginal people in custody, such as relying on imprisonment and arrest only as a last resort, decriminalisation of offensive language, and upholding a right to bail. Not only have governments not implemented these recommendations, but they've deliberately defied them, including through policies of mandatory sentencing, presumptions against bail, and the increasing criminalisation of minor acts such as violating traffic rules. So today, the number or the proportion of Aboriginal people in prisons has gone from 14% 13 years ago to 29.6% today, and it's largely due to a law and order agenda that discriminates against First Nations people. And I also want to say it's not just about the fact that there is over-policing and over-incarceration, especially of Aboriginal women and children. It's also the circumstances in which Aboriginal people die in custody that is particularly horrific. There have been studies to show that they receive lesser care, that, for example, in the work of Dr. Megan Williams, a Wiradjuri scholar, that there is no culturally appropriate care in custody. So many First Nations people are dying in circumstances of callous neglect and violence. And we can see this, there are so many examples. I mean, we saw this amplified last year with footage shown again of the death of Dunghutti man David Dungay Jr. in 2015, where a knee was pushed into his back while he screamed 12 times, "I can't breathe." We also saw this recently with the coroner inquest of Anawan and Dunghutti man Nathan Reynolds, who was not given an asthma plan in prison and treated with reckless indifference when he was suffering an asthma attack that killed him on the 1st of September 2018. So I really want to emphasize that the idea of a rule of law in Australia is a myth. The idea of equality before is a myth when it comes to the treatment of First Nations people. Racial bias runs deep in the penal system and taints every stage of the process. We saw this with Wiradjuri woman Tanya Day, who was arrested in December 2017. She was arrested for being intoxicated. On the same night, a non-Indigenous woman was escorted home and no charges were laid when she was found by police to be intoxicated. There's a very clear inequality that leads to deaths in custody. And we're seeing this now in studies. A recent one found that racism in the police force in Australia is even worse than in the US. So I think it's really important for an international audience to appreciate how entrenched these problems are. And it's why when we talk about the demands that come out of the campaigns led by First Nations families and organisations such as the National Aboriginal and Torres Strait Islander Legal Services, that they're very much focused on shifting the paradigm away from prisons and police. When we talk about things like abolition and defunding police, it recognises that racism is inherent in these systems, that the rule of law does not work for First Nations people. So abolition, while it might be seen as something quite abstract or even academic, is actually something that is practiced and advocated by communities on the ground. We can see this in the calls by Warlpiri people in UNSW to reduce funding of the police in their community and to stop police from carrying arms, from carrying guns following the shooting of Kumanjai Walker. We can also see this in calls to defund police that operate in the work of Deadly Connections in Sydney, where they're seeking to replace the policing of First Nations students in schools with support networks by First Nations role models. So this work can happen if there's a will. In terms of abolition, last year proved with the COVID pandemic that if we want to reduce prison populations quickly, it can happen. But abolition also requires building social relations and networks to protect and care for one another, which is often described in abolition talk as mutual aid. We saw in Australian First Nations communities that relationships and networks were mobilised to provide mutual aid. This was successful in preventing COVID deaths and did not require the police or the state to lead the charge. Arguably, it was successful because of the autonomy and self-determination exercised by First Nations communities. And this is the hope, knowledge, and model that we should be looking towards. Rather, the carceral system in Australia strips First Nations people of their lives and relinquishes blame for the system's responsibility. The rule of law should entail respect for First Nations laws and accountability for a system that has sought to extinguish their lives and harm their families and communities. And I think that any discussion moving forward, like John said, can't start from a position of defensiveness. And as Cheryl alluded to, we need to draw on existing strengths to look towards new systems and new changes that can actually unite us rather than exclude us as people. Thank you.
Thanks so much, Thalia, for sharing your vision and your understanding from your perspective. I think that we'd all agree that respect for First Nations culture, laws, and practices have to be the starting point. And I think that the point you make about racism being worse in the Australian police force than in the United States is something that people might not generally recognise. But I think it is the truth. It's so deeply entrenched. It's probably began from the time of colonization with the way that the colonizers treated Aboriginal people right from the beginning. There was a carceral mentality from the beginning, and that has been perpetuated over the years. So thank you very much for that. Look forward to hearing more from you on that in our discussion section. But our final panel speaker is Barry Duncan. Barry Duncan, known as BJ, is a proud Gomeroi Gamilaroi man from northwest New South Wales. He was born in Moree and is a resident of the Sydney Newcastle region since about 50 years now. He's a father, grandfather and uncle to many. And BJ was a founding member of the Darkinjung Local Aboriginal Land Council and currently holds the role of deputy chair. He has a background in juvenile justice, community development, and currently convenes the Community Participation and Wellbeing Subcommittee within Darkinjung. He's passionate about land rights and community participation at all levels of government, whether local, state or federal. And I welcome you, Barry, to speak to us today.
Thank you, Pauline. And look, first of all, I'd like to acknowledge that I'm on Darkinjung country. I'd like to acknowledge my elders past and present, who are our knowledge holders, and also to our youth who are future leaders for a brighter future. I'd like to acknowledge other Indigenous people that are in the audience, particularly Cheryl. And now that Talia's left, of course, Talia, who never ceases to amaze me. I met Teela because I was on the working group party for the Ulru's statement, and my time in that, Teela was just amazing as well. So, look, my expertise, I suppose, is around the juvenile justice area, but my passion is for land rights. And it fits into pretty much a lot of what we're talking about here today. So with the juvenile justice issues, like John, I'm a big fan of Justice Reinvest. I love the work that they're doing out of Burke. I particularly like the cradle to grave analysis that they did out of Burke as well. And sadly, that cradle to grave analysis could be applied in any one of our Aboriginal communities in New South Wales. I won't speak on behalf of other states, but in New South Wales. I attend children's courts at both Broadmeadow, Wyong and Woiwoi here in New South Wales. And a lot of Aboriginal kids are up for the courts. And like, it's quite an area where you can get disheartened in because it's the same old faces. And unfortunately, when I worked in the juvenile justice system, a lot of those kids I'm doing now are either grandkids or kids of kids that I had in institutions. So, you know, it's that full cycle of that institutional trauma that's happening. It seems to be a bit of the buzzword, the institutional trauma, but nevertheless, it is happening out in their communities. So the kids are now coming back into custody of kids that I had in custody 30 odd years ago. Like John and a few others, I'm really heartened by some of the youth that are out there that don't have contact with the criminal justice system. In particular, I'm talking about the Barang Regional Alliance Youth Leadership Group. So the Barang Regional Alliance is part of the Empowered Communities model, and they help with the local decision-making and the OCA process here at a state level. Those young people that are involved with that are just a remarkable bunch of people that I've used on numerous occasions to do our community consultations and to be involved with the community. And like previous speakers were talking about, I'm excited by what role they'll play within community. So there's a couple of areas I'd like to really touch on, and I think it's been touched on pretty strongly by the rest of the people. But first of all, I'll start with the Black Lives Movement. And the Black Lives Matter movements, to me, is manifest a little bit more about what police do to us. To me, it's about a white man putting his foot on the throat of us as Aboriginal people and not being able to achieve our full potential. And I'm using that sense in the area of land rights, for instance, that we are the biggest landholder here on the Central Coast, is Darkinjung Lands Council. So the former councils, the Wyong and Gossa councils, were amalgamated into the Central Coast Council. In 2000, we were responsible for one of the biggest and major developments here on the Central Coast, where we sold 101 hectares of prime beach frontage land to a group called Mirvac. Now, what happened is, how we ended up with that land is that we claimed that land, and it was common knowledge in council that they laughed because that was the former Wyong tip. So when we all granted the land claim, because it was only vacant Crown land that we would claim, we actually took legal action against the council and won that case, and they had to remediate the whole site. So obviously with the degradation that went on to that site, there was nothing of cultural significance. And yes, the argument that all land is significant to Aboriginal people, sometimes that's the noble savage theory, and that they won't let us participate in the economy. So we sold that land, we tendered for the process, and we ended up with a sale price of 42 million. Now, if you want to talk about self-determination and being able to make decisions in community and run programs that best suits community, what better way to do it than have an economic base, so that you're not going to white government departments asking for a handout to do something that they don't ever want to support anyway, or that they want something that they're going to get out of it as well. One of the most classic examples of that is the Close the Gap. So Close the Gap was never a government mission. That was a local community initiative that looked at some of the underlying health issues that are happening in community. And our communities promoted Close the Gap to address those issues. But then government took over, and then it got lost into numbers and stuff like that. So our community has had losses for, you know, how to come back from Close the Gap to put those figures. But the Black Lives Matter movement, yes, it is about police, but it's about us as Aboriginal people being able to participate in the economic values that are out there in community that our organisations can work towards. Darkinjung Lands Council achieved that with the Crown lands that we were able to claim, but all of a sudden, certainly in that time since 2000, I could see that the goalposts had changed, that they suddenly realised, hang on for a moment, there's a mob of blackfellas here that can do good from this, and there's a mob of blackfellas who can actually benefit from making their own decisions. So the goalposts were moved from us being able to further develop any other lands. But we did do a few little subdivisions that were provided some community housing as part of our program. But the sale of that land from the North Entrance then gave us an economic base to run scholarships, sponsorships, elders programs. We participate in our own Aboriginal-based college and partnered with Barker College in Sydney, who'd be one of the the top 5 private schools in the state. So we run our Aboriginal college out at Yarramal, but it's an opportunity for us to participate and not have government interference. And John touched on that government interference. He knows exactly, what they want from us, and sometimes the demands about the money that's chucking in is just not in our ideals anyway. So us as individual people within community who want to do those development, and once again it gets back to that noble savage concept, is that we just go out and stand on the land, a leg up, holding a spear and stuff like that, doesn't sit with us well. If anybody's going to do any sort of development that is culturally appropriate, it's us as Aboriginal people. And I think we keep that in stock. So one of the other things about Black Lives Matter is that we've got non-Aboriginal people running tours of our culture and making a tremendous amount of money. And then telling us that we're not capable of doing developments and that we're not capable of running our own tours. At Darkinjung, we frown on that very seriously because we are culturally responsible and we have got the cultural authority here on the coast. So the Black Lives Matter movement, to me, has expanded a lot more. So with the statement from Uluru, from the heart, I think it's pretty much been covered. A lot of people have spoke to that. It was one of the most amazing events that I have ever been involved with. I took part in the Sydney dialogues. I went out to Uluru, took part in the dialogue out at Uluru, where the statement from the heart was authorised. I would just say one thing about the statement from the heart, is that White Australia thinks they're going to lose 250 years of history. They don't ever think about they will pick up 60,000 years of history. It's not, it's a really important point to make. Certainly, we don't want to claim the 250 years, but it's that 60,000 years of continuous Aboriginal culture that exists in this land is a point that I want to make. Can I just say that the times that I've worked with kids in custody, and I've seen a cycle of that institutional trauma that comes out, I actually chair the New South Wales Community Legal Centre's response to the family's culture, a report put out by Megan Davis that looks at that home care of our youth. I'm sad to say the Central Coast currently has over 700 children in out-of-home care. For the government to fob off not just the Royal Commission into Aboriginal Deaths in Custody report, but to also fob off the family's cultural report by Professor Megan Davis is just appalling. I can go back and name a number of other reports. So the Royal Commission was one. I can go back to the Lowell Munro Jr. and Chris Milner did a report into kids in institutions way back in the 80s. We've been reported on, reported against, and yet there's still nothing that changes. The Central Coast is home to just over 14,000 Aboriginal people. I'm battling with police at the moment. We just want an Aboriginal community liaison officer in a position that'll be able to help community and help police. But I pick up the paper and I see 5 new blue shirts, that they're going to put at Tuggerah Lakes Command. I see another 4 shirts that they're going to put at Brisbane Water Command. And yet they tell me they've got no funding for an ACLO for that position. Sorry, they tell me all the time that position is coming, but when it comes around, they haven't got the funding. And then before it goes back on the burner. So I was quite happy to go to one of the PAC meetings with the police Aboriginal community consultation committees. I was happy to go and kick a chair over and shake a few feathers. But, we've had a change of command. The inspector at Gospel Police, a guy by the name of Brett Greentree, assured me that it's definitely not off his radar, that he'll be chasing up. And Brett was a former police officer in Moree. So after I got off from talking to him, I rang my ACLOs in Moree, guys that I've grown up with, and I asked them about this Brett Greentree, and they seem to think that he's a man of his word. So I'm happy to go along those lines. And I'll wait to see exactly what happened, but I'll be kicking over another chair in another 2 months if that's the case and I get told the same old stories. But the big thing that we do at Dark and Young, and it's entirely everything that Teela talked about, I think Cheryl mentioned as well, Thalia and John, is that we are self-determining our future. We're not putting up with this stuff. It's quite, since we did the big development at the north entrance and we got the big money, councils have been moving the goalposts. We've challenged those now, the council, the racism, and I believe it is just racism, inherent racism, council about us not being able to produce or develop our own lands, that we went and got our own building code so that we could bypass council and go to the minister, who agreed at the time when the SEP was done that he would just sign off on it. But unfortunately, he then was replaced in a cabinet portfolio shuffle. We inherited somebody who's not as tolerant or not as keen for that SEP to actually get over the line. And it frustrates us, is that, not only do we pick up some of the slack, like the Department of Housing and Building Properties for our members, otherwise it'd be looked after by Housing New South Wales or other housing providers. Not only are we helping with some of the scholarships and sponsorships for people to either, get further education and stuff like that, that could be picked up by TAFE, but we're actually contributing to not so much of a debt for the state, for our members as well. Yet we're seen as, the troublemakers and played up against by other groups pertaining to have native title. So on the Central Coast, that native title stuff is an issue with us. And as yet, we made a motion at Dark and Young some 8 years ago that we wouldn't be the second round of dispossession. Obviously, the first round of dispossession was Cook. Our second round of dispossession, we said, go away, get all your information together, put it to the federal court. To date, nothing has been put to the federal court, and as a fact that it's been discontinued in the federal court. So we will assert our cultural authority, and we'll look after not only just a family of 4, but our entire Aboriginal population here on the Central Coast. And I'd just like to congratulate everybody, particularly John. John's been a friend for many years. I was amazed at the work he did with the Royal Commission. Cheryl, having worked with ALS, I find it incredibly frustrating. We get a large Aboriginal population in juvenile justice centres and the adult correction centre, yet there's our Aboriginal legal service has been cut to smithereens, and lack of funding for those services to provide culturally appropriate legal opportunities for those people that really need it. And I can attest to that. I've actually stood in a court with some juveniles who had no representation, and the magistrate said, well, look, I'm going to adjourn it. They had to go on the next morning, they had to be in line at legal aid, and if they weren't the first of 12 at legal aid, they weren't seen, and then having to come back to court. Then there's the non-appearance at the court, and it just still goes into more issues as well. So I thank everybody for the opportunity to come in here and speak to the rule of law. I thank Pauline for the opportunity, and just keep up the great work, guys.
Well, thank you very much, BJ. I think that's really insightful, and I think that perspective of the foot on the economic throat of Indigenous people is a really important point to remember. If we're going to have self-determination for Indigenous communities, which is recognised as being the fundamental thing, then economic self-determination has to come up there really as a front runner, because without money in today's world, you can't have programs that are effective in addressing systemic problems within communities. So thank you very much for those insights, BJ. Look, we've got time for about 15 minutes of discussion among our panel. So I'd like to perhaps address a few questions to the panel. Black Lives Matters seem to have captured public attention in Australia, that movement, in a way that that other things haven't. I think the Black Deaths in Custody Royal Commission report garnered some attention at the time, but fell away. It's 30 years and those recommendations haven't been implemented. But last year, with the Black Lives Matter movement and the demonstrations, it's put this issue back on the map. Would any of you like to comment on why that might be?
So, Pauline, our Black Lives Matter movement here on the Central Coast, the march was organised by the Barang Leadership Group, who I spoke about earlier. And they coordinated everything on the day, including speakers and stuff like that. It's the first ever march, I might add, that's ever been on the Central Coast for Aboriginal people about about any issue, regardless of Black Lives Matter. And the thing that was so impressive is the numbers that turned out. But I could feel certain frustration from those young people who participated. So they marched, and spoke and stuff like that, wanting change to happen, but not realising us as older people know that change is slow and it's a hard-fought process. So I think, there was a lot of frustration about the Black Lives Matter march here on the Central Coast. Which doesn't deplete the importance of it by any means, but it's certainly, it was a long time afterwards that we had to pick up a lot of that youth leadership group from it.
Thalia, I might address this one to you. You spoke of the death of 26-year-old David Dungay in Long Bay Jail. That, in 2015, that attracted little media or government attention in Australia when it occurred, despite the obvious similarity with the death of George Floyd in the United States, especially those last words spoken by both deceased, with Duncan saying, "I can't breathe," 12 times before he died, while being restrained by 5 prison guards. Yet none of the guards faced action, criminal action, in relation to that matter. In the United States, we've actually seen the conviction of the police officer who held George Floyd down. What do you see as the difference between Australia and our response to Duncan's death and in the US that led to such really different outcomes?
Yeah, I think it says a lot about our system. I just want to say it was a really interesting time last year because I'd been to the rally, I think, every year since 2015, mostly at Long Bay, sometimes at Town Hall, and there were no more than a few hundred, and that went to, you know, tens of thousands. And I think it was what BJ suggested, this real hope that it will lead to change. I mean, people don't just go on the streets to virtue signal, although there might be a bit of that. I really think that there was a passion for change. People felt it was the moment. And it led to, you know, petitions calling for prosecutions. It led to an inquiry into deaths in custody in the New South Wales Parliament. But none of these have led to even disciplinary action, not to mention charges or prosecutions or convictions. Like, we are so far away from getting to a situation like with Derek Chauvin, where there is some degree of accountability, where we actually stop valorizing police lives as though they're above the law. And, you know, there are many reasons for that. There's a really strong police union movement that will absolutely go out and bat for their officers and make them martyrs, essentially, as though the system is doing an injustice to them when it seeks to or tries to investigate, which are really Pyrrhic investigations. Cheryl mentioned police investigating police, which is another major inhibiting factor. But there, you know, there's also a media that often produces verbatim stories based on police media releases. So there's all these social forces that work against humanizing the person who died, you know, and focus on, even with Kumanjai Walker, focus on Rolf, who's responsible as an upstanding citizen who served his country. I mean, what about the life of a young person who was, you know, part of the glue of that community, you know, who was the future generation of their culture and a future cultural, like, why don't we hear that story on the front page? And I think that the protest, but also all the advocacy from so many different sections of society needs to be part of humanizing the people who are being killed by this system.
Thanks.
Yeah.
Cheryl,
Yeah.
I'd like to invite you to say something about that as well, if you would.
Well, I think, you know, it's been captured really well in the context that, you know, in the global movement in Australia, but we had all these young people in each state and territory connecting and making sure that they were connecting also with international context in regards to the Black Lives Matters campaign, which I think is really welcomed by, you know, Aboriginal and Torres Strait Islander peoples, because it lifted the voice of the concerns, and it shone the light that this is no different. This is happening in Australia all the time. 470 deaths without accountability. And there are a lot of those deaths that are very suspicious deaths, and that they should be properly investigated and charges should be laid. That's as simple as that. And I think and I'm just picking up the point there in regards to, you know, the strategy that governments and police use by utilising media, by the very strong police unions. There's a very strong prison union who do very similar contexts, that the resource is there to continually demonise the person that has died in custody. But also it comes back down to racism. But we see a lot of difference happening between our people and our women in particular dying in family violence situations. And yet we see very different media coverage when a non-Aboriginal woman dies, as the same result. And that's not taking anything away, because violence is violence and it should not be accepted in any shape or form. But the value of the lives of Aboriginal Torres Strait Islander peoples in this country is not valued to the same level. And that's the issue that we need to be dealing with in this country. That is just pure racism, and we need to start addressing that.
The other aspect of racism, Cheryl, is the over-policing issue. I mean, I've used the analogy of the blonde-haired boys from Bronte, skylarking and having a sort of larrikiny good time. And yet if that was a bunch of black boys in Burke, it would be a whole different story, wouldn't it? Can you tell us what that over-policing looks like and the exercise of discretion looks like on the ground?
Yeah, well, police, are supposed to be, supposed to have a reasonable, grounds to stop people. And, Aboriginal Torres Strait Islander children and young people in particular, even adults, walking down the street, you're more than likely to be stopped by police officers. We know this happens to our kids all the time, and kids who've never, ever been in trouble with the law are constantly stopped. This is part of what we've grown up with, and it's unacceptable, but that's the reality of the policing. And also what we do see is we now see what I call more intelligence policing happening now, where there are profiles being conducted on young people within communities who are not even offending, but they may be related to a cousin or brother or sister, whatever it might be, father, whatever, and now they're being targeted by police. So, and the police think that that's a good strategy because they think that the people who are committing crime are going to change their behaviours. Well, what it actually does is actually creates a lot more resentment of our young people with police, and the police relationships. We don't go to police officers when we need help. Aboriginal women do that when they're facing family violence, and yet they'll get arrested for a non-payment of fine and end up locked up at the same time as the perpetrator is. That's the experiences of Aboriginal Torres Strait Islanders in this country, and that's the reality.
And I think that example given, I think that was you, Thalia, speaking about the Sandra Gay versus the white woman on the same night being arrested, and the one being arrested and taken to the cells and the other being escorted home without charges. Tanya Day is very telling. I think we must address that. Another issue is the how is it that Indigenous kids, maybe this is something that BJ can comment on, do come into contact with the authorities at such an earlier age? Is that because of police profiling in schools? Is that what it's about, do you think, BJ?
Yeah, definitely, Pauline. So what happens here on the Central Coast is that the police carry out what's called STMPs. So it's Suspect Targeting Management Program. They will pull up kids and harass them to see if they've got a bus ticket, to see if they've got a train ticket, see if they've got money in their pockets, where they're off to, where did they get the money from. I actually took one of the inspectors of police to task on it. And the only excuse he could give me for those STMPs was it's an opportunity just to harass kids. If that's not poor police management, I don't know what is. At one stage, I was doing a program with a youth service here on the Central Coast. So I had 3 of the young men involved on the Central Coast. And at that time, they were committing 30% of the crime in there. So, that they knew what they were doing, police knew that. But there was periods of time when those kids were doing really, really well. And, any win with a young offender is a good win. But when those guys were doing really, really well, they'd take one contact with police and the police would harass them. They would then return to their former offending behaviour because that's what the police expect of them. Yeah. And, first contact with police, I still shake my head when I go to the courts now. God, we've got kids going to court because of they've been fined for riding a skateboard on a station. Is that what we want our kids really appearing for? some of the graffiti laws, I think, are a little bit outdated now. You know, kids appearing and getting quite serious offences just on for graffitiing. Yeah, and I understand some of the issues about what community thinks about graffitiing, but a lot of the kids that I come in contact with are perpetrating crime because of crimes of poverty. And that goes back to that self-determination issue that we're addressing here on the Central Coast.
Thanks, Peter. John, I'll address this to you. How would you see, this has been raised by other speakers, but how would you see raising the minimum age of criminal responsibility and perhaps changing bail laws? How would they make an immediate difference on the ground? Are you on mute?
Sorry, was that
John? I'm after John Mckenzie.
Oh, okay. Sorry, Pauline. I wasn't sure who it was meant for. Look, any move to reduce the number of Aboriginal young people coming into the criminal justice system is good. No doubt about it. It would be wonderful. It would actually only just start to bring Australia in line with, quite frankly, the majority of other nations who hold themselves proudly up to the standards of international human rights. So I think that it is a good thing. Again, I would say, though, that even if that's done, and hopefully that might actually be done, because it seems to be a gradual, moderate thing that even the reactionaries may allow to go through. I think that we need to be really careful, and that's not going to it will help, but it is not going to by itself solve the myriad problems that First Nations young people are encountering right from basically the day of their birth. We need to really go back and look at this, and we've talked about people, police, other people working in the system. And they do some really bad things. There's no doubt about it. There are a small number of really good ones within that cohort too. I want to say that. But the ones who don't do the right thing, in my observation and experience, really it comes down to this. It comes from a fear of an unknown culture. To me, I think that a fundamental issue we've got in Australia is that the Aboriginal cultural heritage is of such wonderful diversity and complexity that unfortunately through what we've done in the last 250 years, because it's too hard to get our westernized minds around it, then it can't be good, it must be bad, it's feared, so therefore we're going to not even attempt. See, one of the things that I think you can really do to affect change within all of the systems, especially the criminal justice system and our education system, is really put a lot of effort into getting the people, your officers, your teachers and all the rest, to actually take some serious time and tuition to actually get into the marvel, if you like, the wonders of the cultural heritage and traditions of the local Aboriginal people where they are working and trying to perform. I always thought that as a long-term lawyer for the Aboriginal Legal Service, and indeed working on the staff of the Royal Commission as well, that one of the great challenges of doing that is absolutely you need to bring your professional credentials along, otherwise you're no use to anyone. If you're pretending to be a lawyer, be a really good one, because these people need the best. But the other side of it is that you need to be on a daily basis accepting that you have more to learn from your Indigenous clientele and family groups than they will ever have to learn from you. And once you start to get to that point of realizing that every day that I'm doing this role, I need to be consciously aware of the fact that there is a cultural difference. It's not good, bad, better or worse. It's simply different, but it is wonderful in its myriad of complexity, in the explanation that it can give for the wonderful environment that our country is. There is so much to be gained from it. And what it strikes me as being is that we really need to get back to that, but not in some offhand tick a box way where you do an hour or two of so-called cultural acclimatization or tolerance or whatever they call it these days. It's just too bureaucratic. It's not working. That's my final word. Thanks, Pauline.
Thanks a lot, John. Look, I think, you know, we know from statistics that Indigenous people in Australia fare worse, not just in terms of minimum age of criminal responsibility, but at every stage of the criminal justice process compared to non-Indigenous people. I think some of the stats have been referred to, but in 2016, they were 7 times more likely to be charged at all with a criminal offence and appear before the courts, 11 times more likely to be held in prison on remand without bail awaiting trial or sentence, and 12.5 times more likely to receive a sentence of imprisonment following conviction. So it's not just that Aboriginal people are somehow more inherently criminal, as the statement from the heart says. There's got to be within Australia an understanding of that close connection between the history of colonisation and trauma experienced by First Nations peoples and subsequent interaction with the criminal justice system, and that removal of children and the care system and the correlation of that with the criminal justice system. And we've got to move away from punitive to preventative and trauma-informed approaches for any difference to be made. What I'm hearing from all of you today was that we've got the answers to a large degree in all of these reports that have been done, including the very important Black Deaths in Custody report, as well as the Australian Law Reform Commission's Pathways to Justice final report. But there's only been sporadic, if any, engagement with any of those recommendations, and certainly not with the Uluru Statement from the Heart. So I'll ask each of you to reflect on what we can do to get government to start implementing these recommendations that we've already got. Cheryl, we start with you.
Well, I've always said that we've got to start with truth telling in this country, you know, and that's part of the journey of getting the rest of Australia to understand the issues that are actually happening in this country, which are constantly masked by governments and by media. That's number one. Number two, I think, is, you know, giving back our self-determination, giving us the responsibilities in our communities, give the funding to our communities so we can develop and run our own programs, because they've proven, many programs are out there now, are proven to work and have been successful. The issue is about the lack of investment and ongoing investment and funding within government. And we'd love to get to an economic base where we can actually do this ourselves. But unfortunately, you know, native title or land rights is not available to everybody, you know, in our country. But I believe that there's a way forward for us to be considering, and we're only just starting to think about that now, I think, as a nation of Aboriginal and Torres Strait Islander peoples. So philanthropic supports, but the biggest thing, number one, is we need non-Aboriginal voices to continually to be raising and speaking up on these issues, because our voices are continually, we're tone deaf to government. And, you know, rest of society now, it's your turn to stand up.
Thank you. John, did you have anything to add?
I just would add this, is that until a sizable, a real majority of Australians are not going to put up with their governments continuing to perpetrate this national scandal. So until we get the breakthrough of mainstream middle Australia to absolutely demand that their politicians take real action, that's what we've got to do. Now that's a very long and can be a complex thing, but we need some people with great leadership and insight and vision, and we need everyone who wants to support this cause to come in and join that, because until the politicians feel that they will not win the next election until they properly address this matter, that's the time when it's going to change.
Thalia? I think you're on mute.
She had to leave.
Yeah,
Oh, I'm sorry, BJ, final words from you.
Final words from a not so old person, I suppose. It's about getting Aboriginal people involved in all levels of government for me. It's both the local government, it's state government and federal government. Those guys in the federal house, the Pat Dodsons, the Linda Burney and those sort of guys, they mightn't get acknowledged so much for making change, but if they're in there trying to stop that great big wheel of government from turning one direction forever and ever, I applaud them. But, we need to get a lot more people, Aboriginal people, in decision-making roles so that we can, as John said, that educate people, one, about our culture, our aspirations and our right to self-determination, that they can't ever control.
Right. Well, thank you very much, BJ, and thank you to all our panelists. I think it's been a really exciting, certainly stimulating discussion today. And I'm sure that our international audience have learnt a lot. It's sadly time to wind up. So on behalf of the New South Wales Council for Civil Liberties here in Australia, I'd like to thank each of our speakers today for so generously giving their time and their thoughts and their really deep insights. And thank you to everyone joining us on YouTube for this session. I hope you've enjoyed it as much as I have. This unprecedented 24-hour webathon, lawyers across the globe and around the clock for the rule of law,